In fact, this subject of criminology, which is in fact scientific study of crimes, criminals, and dispensation of justice, is very close to my heart. And that is the reason that despite having hectic schedule and ailments, I am in this conference. In fact, in recent, in present times, people are losing their precious lives, honor, dignity, and respect, movable and immovable properties. But whether these victims are getting justice, it's a big question. I think no one would say amongst the participants yet that yes, they are getting fair and impartial justice. The reason is very much obvious, and it is very much clear from the lowest percentage of conviction our country have around the globe. Unfortunately, the conviction rate in our this beloved country is only 7 to 8%. In contrast to our neighboring country, India, 37 to 38%, USA 87%, and UK 90%. In all these countries, the system of criminal dispensation of justice is based upon adversarial mechanism. This adversarial mechanism is placed in all those countries, in all those common law countries, where in contrast, inquisitorial system is placed in the countries, civil law countries across the globe, like Germany, France, Japan. In fact, in this criminal dispensation of justice in adversarial system, the roles of the court, judges, and worthy presiding officers are very limited. They can only act as a neutral arbiters. They cannot intervene, interject, interfere in the investigations, in the prosecutions. Rather, they are deciding the cases on the basis and strength of the evidence so placed by the prosecution and so collected by the investigation officers during the course of investigation. So the role of the court and worthy judges and presiding officer is very limited and only confined to the evaluation, examination, analyzing the material which is being placed before them in shape of evidence and other material collected therein. But keeping in view this disconnect, in the year 2005, Prosecution Act was introduced, and a forum and authority was introduced by virtue of that very act of the year 2005, which provides deep insight, advice, and guidance through the office of the worthy DPPs, District Public Prosecutors. Now, the moment an FIR is registered, a copy of that very FIR is directed to the office of the worthy DPP. And upon the receipt of that very copy, his role starts. And he is obliged under the law to provide guidance, advice, till the time the final investigation is concluded and the same is placed before the court for trial in shape of the challenge. Now, here we are facing a huge problem because the law has provided enough force and strength by introducing a statute of the year 2005. But whether that authority is properly exercised by the worthy DPPs or otherwise, again, it's a big question mark. In recent past, while hearing a bail application, I found that the investigation was defective. Proper care was not taken by the IO. And in fact, he destroyed some material evidence. I immediately, while exercising my inherent powers, order for the change of the investigation officer and also directed the competent authority to inquire into the matter, that why in this particular case the material evidence has been destroyed by the IO. Whether it was intentional, whether it was unintentional, or whether it was due to lack of his capacity and oversight by the DPP. I also immediately directed for the appearance of worthy DPP of the district concerned. I confronted him that whether after receipt of the copy of this FIR, you have provided your advice and the guidance in accordance with the mandate of the law or not. His answer was, yes, I had provided the same, but it has not been acted upon. I confronted him, where is that advice? It must be in written form. Where is that? That was not available. I immediately write to the worthy DG prosecution to inquire into the matter and proceed against that very DPP. Know whether we people have sufficient time, the judiciary, to scrutinize each and every case, that whether proper advice, guidance has been provided by the worthy DPPs to the IOs, whether the IOs have properly conducted the investigation so assigned to them, or whether it is next to impossible. In fact, this is the domain of the worthy investigating agencies. In each and every district, there is superintendent of police investigation, SP, we call them SP investigation. This is his mandate to look into the performance, to look into the investigations carried out by the worthy IOs, and then the supervisory role of the worthy DPPs. If these two posts have been created only and only for proper investigation and proper oversight of that same investigation, whether these two forums and authorities are exercising their jurisdiction authority in accordance with law or otherwise. If they are not performing, definitely it would result into grave injustice. And in the words of Martin Luther King Jr., injustice anywhere is a threat to justice everywhere. To me, the definition of justice is when both the parties walk out from my court, they should walk out, and they must walk out with the impression that justice has been done to us. If any one of them walk out with the impression that injustice has been done, then I'm liable. The investigation agencies are liable. The DPP department is liable. The whole infrastructure and state is liable for it. And it's high time that there must be proper mechanism of accountability. If I am sitting and I'm not delivered, then I should be held accountable for it. If the investigation is there, but due to reasons best known to them, they are not delivered, then the accountability must be there. Likewise, in the office of the worthy DPP, accountability must be there. If we are not going for proper accountability, then definitely the authority sitting at the helms of affair would be surely failing in the discharge of their responsibilities and duties so mandated by the law. It's very strange to note that the Constitution has provided in clear and loud words that the state shall ensure inexpensive and expeditious justice. Whether again it's a question that people are getting inexpensive and expeditious justice. Again, the question is big no. If my courts are failing to decide the case within the time specified by the law, it's my failure. When the investigations are not concluded within the period assigned by the law, again, it is the fault of the investigation. If there is not proper oversight within the period provided by the law, by the DPP office, the buck stops there. Now, I would be coming to another important aspects of the matter, and that is that whether only and only these departments are responsible for this injustice to the victims or otherwise, the answer is again no, is a big no. We are not only responsible. Neither the investigation is wholly solely responsible, nor the prosecution, nor the judiciary. In fact, the victim, after the occurrence, if he is going and falsely nominated accused, if a crime has been done by a single accused and he is going to nominate three persons, then he would be committing injustice with the two innocent persons. Likewise, if he is going, crime has been committed by one person and he has charged with exaggeration a good number of people, again he would be doing injustice to those who have been falsely implicated in all these cases. Then there is another phenomenon. In most of the cases, the in charge of the police station, sometimes, not every time, rather sometimes, go for making unseen occurrence a seen one. Because if he left the occurrence unseen one, he would be asked and he would be taken to task that why in your jurisdiction this unseen occurrence has been committed and who has committed it. Just to ward off this responsibility, he is going by all means to make an unseen offense a seen one by pressurizing the complainant, the victim party, to nominate a person or accused by name. So here, the injustice has been committed by the in charge of the police station. So the responsibility is a collective responsibility. Society is responsible. I am responsible. Investigation is responsible. Operational police force is responsible. DPP is responsible, and we all are responsible. Now, how to tackle with this situation? We have not only to educate ourselves, we have to educate the victims, we have to educate the accused. And who is to do it? When I was going through the definition of the term criminology, it's a scientific study of crimes, criminals, and criminal dispensation of justice. But we cannot include the role of the society in this definition and the role of the victim in this definition. And if I get a chance, I would do these two forums in this definition also. It is not only required the study of crime, criminals, and the criminal dispensation of justice, rather the role played by the victims, the role played by the other segments of the society. Being son of the soil, we all are aware that only the weakest and voiceless segment of the societies are rushing towards the police stations for the redressal of their grievance and to the courts for the same purpose. Whether you people have ever seen that a person who has stick in hand, who has authority, who has settled his scores on civil and criminal matters across the aisle, he would ever go to the police station for resolution of his dispute? Or he would go to the courts for resolution of his matter? Definitely and surely he would sit and settle down by the strength and dent of his own force and authority. And in our terms, we call it anarchy and rule of jungles. Let's join hands to strengthen all these segments of the society, as well as all these stakeholders of justice system, to deliver proper justice to the citizenry of this country. You would not find any false implication case in Europe, in America. You would not find any case there of exaggerated charge. You would not find anyone who has got no capacity and he has been assigned the task to investigate the matter. Likewise, you would not find a person who has no capacity of oversight, but still he has been given this authority. If a person has no mercy, no sympathy with himself, with his family, with his kid, then why I should protect him in the department or in the service? Let he should create space for fresh, competent, vibrant, active person who can replace him. We should not show mercy when it comes to accountability, when it comes to injustice to the victims and to the society. Rather, we should go for the accountability. This prevalent system would continue and exist till the time we introduce the proper mechanism of accountability. Laws are there. I am going to be held accountable through my own institutions, and that is our Supreme Judicial Council, which is headed by the worthy CJP, two senior most judges, and two senior most Chief Justice. Upon receipt of the complaint, they have to scrutinize the same. And if there is any violation of code of conduct of a judge, he would be taken to task. Recently, two persons, one has resigned, the other one has been booted out from the system. Despite his resignation, judgment was given by the Supreme Judicial Council that now once a person has been served with a charge sheet, then that is to be investigated. It is to be pushed towards the logical end, and even during that very inquiry or scrutiny process, if he's going to resign, that resignation cannot be accepted. Rather, he is to be shown the doors unsurmountable. Whether in your universities, in your institutions, is there any mechanism of accountability? Again, the law has provided a mechanism. If a person who has 20 years of service in terms of Section 13 of the Civil Servant Act 19 of the Khyber Pakhtunkhwa Civil Servant Act, and he is not performing, he is to be served with a show cause notice, and he is to be compulsorily retired from the service in order to create space for young, energetic, vibrant, robust person who can take in the charge and start delivering. Whether you people have removed any person, yes, in the judiciary, We have removed a good number of judges. And we are regularly passing through that very process. And we have full belief and faith and always religiously following Section 13 of the Civil Servant Act, which is very much clear. So let introduce and act upon the system of accountability across the board in the society. Let we should not show sympathy. If a person is capable and he is holding at a position and he is not ready to change himself, he is not ready to improve, enhance his capacity, that whether that very person still has a right or claim a right to hold that very position or otherwise. I started from myself. I have stated to my colleagues as well as the members of the district judiciary that no, we will not tolerate. Either we have to deliver or we should say goodbye to the institutions by providing opportunity to others. Another question arises whether the formal judicial system is capable of delivering justice to its citizenry of the nation and countries. This very question was answered by a legal wizard, legal philosopher Russell Pons in the year 2006. Sorry, in the year 1906. He introduced and he came out. He also remained the dean of Harvard Law School. He came out with his findings that the formal judicial system is not delivering. It is creating hurdles for the litigants. It is not cost effective. It is not time effective. It is full of technicalities. It is non-conclusive. We have 4 tier of the justice system. आप trial court जाएंगे, आप appeal court जाएंगे, आप revisional court जाएंगे, and finally you would land before the Supreme Court. It is not swift. And these were his findings in 1906. Later on, after 6 long decades, Rosbon Conference was held in America in the year 1976, followed by the first ADR mechanism in the USA in the year 1980. And formally, it was held by the legal wizards that it's high time that let the world should move from formal judicial system into informal judicial system, which is based upon mediation, reconciliation, arbitration. And since then, it is successfully installed in America, in UK, and in Europe, and now in the South Asian state as well as in the Middle Eastern countries. And the proponents of this very system are agitating that this very mechanism is time effective, it is cost effective, it is conclusive, it is free from technicalities. In informal words, we call this ADR mechanism is JIRCA system. If a dispute arises and the disputing parties approach to the mediator, he would sit and he would resolve that very dispute between them. A reconciliator would be appointed and he can resolve this dispute for them. In legal parlance, arbitration can also be done by the appointment of neutral arbitrators. And this is the most celebrity mode of resolution of dispute on criminal side as well as on civil side. Even it has been introduced in labor laws as well as in the service laws also. This opportunity has been provided in the Police Order 2002. It was also provided in the local laws. It has also been provided in our codes also. And this is also the mandate of Holy Quran. When a dispute arises between believers, then resolve this between your brothers. This is verse number 10 of Surah Al-Hujurat. And again, the verse number 35 of Surah Al-Nisa. If a decisions occur between the two, then appoint, particularly in the matter of females, and a reconciliator from his side and a reconciliator from her side. And if both the reconciliator wish, will, and desire to resolve this issue between them, then surely Allah will make good between them. This is the mandate of Quran. This is the mandate of modern time and modern legal dispensation of justice. So, no, slowly and gradually, while following these principles and this mechanism of ADR, High Court Peshawar across the province, we have established ADR courts. We have introduced the ADR mechanism in cases and matters arising out from inheritance matters. We have introduced it in criminal courts as well as in civil court. And you people would be astonished if you hear that one of presiding officer in past 1 year has disposed of more than 15, 16 or more than that cases of single murder, double murder and triple murder cases to the mechanism of this reconciliation, and we remain successful in doing that. So now we are slowly and gradually moving to that very mechanism also. But if the parties are not ready to decide or resolve their dispute through ADR mechanism, then what we should do? Then we have in all the circumstances, if people are going for resolution of their dispute to ADR mechanism or otherwise, but we have to strengthen all the departments governing the formal judicial system. While going towards the ADR mechanism, we cannot abandon our formal judicial system because most of the time and for all the periods, people would not be ready to resolve it. So let's start an initiative, and it would be the new beginning. In the words of Liu Tzu, a Chinese philosopher, 1,000-mile journey begins with a single step. We should take this step, and Allah will help, support, guide us in our all these endeavors. Allah will surely support us. Any questions from the participants? Yes.
Thank you, Mr. It was indeed